May it please the Court, Your Honors, Bernard E. Gozzi, Isaac Liu, and Carolina Schneiderman on behalf of defendant Imico, Brickell, LLC. This case stems from a breach of contract and a declaratory relief action filed by David Yu, who was a sophisticated and experienced real estate investor who put down a deposit to purchase a pre-construction condominium unit developed by Imico, Brickell, LLC at the 1060 Brickell project in Miami. The contract was signed in March of 2005.
Well, help us understand how the amendment could modify the contract as to closing date. I see paragraph 28 has the July 1st closing date. So how do you amend that?
Well, actually, Your Honor, it's the July 1st, 2007 estimated substantial completion date. The closing date is triggered by when you have a substantial completion date that happens afterward. In June of 2005, the developer, as it has the right to do under the statute, sends amended condominium documents to Mr. Yu as well as all the other buyers, indicating that July 1st, 2007 is not going to be a date where we're going to estimate we're going to be able to complete by.
But a change to the prospectus would not alter the term in the contract, would it?
No, it would not modify the terms of the contract. However, the conduct of the buyer by not rescinding the contract, the developer takes a big chance of sending out this amendment to the prospectus and saying, buyer, you have 15 days. If you're not happy with this change to the offering, you can send us a letter back rescinding and you get your money back.
Oh, but if I'm the buyer, I've got a contract. It tells me something about the TCO as a possible completion date. But if I want to know my completion date, I'm looking at paragraph 28, and I'm seeing July 1st, unless extended by construction difficulties, force majeure, etc. So I'm looking at July 1st. Now, what is it mechanically that says that a change to the prospectus makes it mandatory for me to give you a notice terminating the contract? Where is that?
Under 718-503, it requires.
No, doesn't that really give a buyer one form of right if you materially and adversely change the condo docs, meaning the declaration and so forth, I have the right to get out. But that's a one-way right, isn't it?
It's a one-way right on behalf of the buyer to get out.
What turns it into a duty? What says you must do this if you want out?
Correct. The statute.
No. Does the statute tell you must do this? Or does it say you may do this if there's an adverse change?
It says you may rescind the contract. Right. Otherwise, you can live with it, and he testified at trial that he agreed.
But it doesn't say you must live with it if you don't exercise that statutory right, does it?
No, the statute does not say that. However, when you read the contract law and interpreting the conduct of the parties,
but if you just confine yourself to the contractual rights, this is a modification of your rights to their detriment without consideration, isn't it?
It's not, and there's case law and it's cited in our brief with respect to 718. The fact that we're sending out a decision letter is sufficient consideration.
Let's say we have no prospectus, no nothing. It's not a condo. It just says the closing date or the completion date will be X. After a while, you write a letter and say the extension date or the completion date or whatever is now Y. If you don't accept this, you have to. What is the consideration for the Y?
The consideration is the offer of rescission, and that's what the case law says, that by sending, and under 718, sending out material and adverse change.
Let's say the premise was there is no condo. There is no 718, there is no nothing. This is just a contract. What is the consideration for extending the agreed upon date of conclusion?
The agreement on behalf of the seller to give back your money if you don't want the unit.
Well, you have to do that. That's an agreement of something that you have to do. If you don't complete your contract, if you don't abide by your contract, that's this case. This is what happened. If you don't abide by the contract, you have to give it back. It is no consideration to do what you have to do by law.
Correct, Your Honor, but by law, a developer of a condominium development is entitled under 718 to send out that material and adverse change, and that is
we're back to the question of Judge Salford. Yes, you have a right and an obligation, as a matter of fact, to send it out. There was no obligation on the part of the buyer to say, okay.
If they want to rescind the contract and get their money back
Well,
because of that change, they do have that obligation.
Well, look with me at 19C, if you will, in the contract.
Yes.
Because it does speak to amendments to the document. And so it tells the buyer, if I change certain things, you'll have a contractual 15-day right. It more or less parallels the statute. But look at that one. My problem is that as I look at the condo documents that can be amended in this fashion, I don't see the prospectus included as one that can be amended to the hazard of the buyer.
Correct, and in fact it says that it incorporates all of these condominium documents, however, it does not change the terms. And we're not arguing that we change the terms of the contract. We're arguing by the conduct of the buyer in saying, I'm going to tolerate that new date. You're telling me 2 years in advance you're not going to be done.
But their toleration is not consideration. And it is also not agreement, and there's not estoppel. There's not anything.
See, toleration is one thing. Accepting is another. And what I'm looking for is the evidence in the record or in the contract that Mr. Yu was bound to that November date, even though there weren't those extenuating circumstances.
And the evidence of that acceptance is on August 22nd, 2007, he sent 7 weeks after, he sends a letter to the developer saying, developer, please postpone my closing date until as late as possible.
And does the buyer accept that? I mean, does the seller accept that? Does the seller write back and say, that'll be great, we'll give you until January 15th? Is there any acceptance?
The seller sends a closing notice on December 31st, 2007, scheduling the closing in January 2008. Yes,
but it never responded to his specific request, did it?
The response
the email that I saw anyway in your appendix is the developer's agent saying, we'll check, see what works, and get back to you.
Correct. We'll see what we can do. They send them that email, and then a couple of months later, they get the closing notice from the real estate lawyer on behalf of the developer indicating that your closing date is scheduled for January 2008. At that point in time, he's given a closing date. He fails to close and makes the argument that we failed to complete by July 1st, 2007.
But of course, on November 15th, he terminated the contract. He demanded the return of his deposit. Had he gotten the new completion date by that time?
Yes, he had already received it years earlier. He got the new.
No. Had he gotten the new closing date?
No, the closing letter went out in December.
Okay.
He sent his letter.
So that came after he had already repudiated the contract.
Well, he sent a letter trying to repudiate the contract based on other reasons, on Interstate Land Sales Act and other claims that...
Yes.
But his notice of termination was before there was any response to his email saying, I might want to close next year sometime.
Correct. August 22nd, 2007, he sends the email. The agent responds back saying, we'll let you know what the developer can do. November 15th, he sends a letter.
And actually before that, when he first gets the notice of the change in the completion date and the closing date, he says, he's not happy with that, but he can live with it. It's then that he requests that it be extended even further past the closing date that is suggested by the developer.
Correct, Your Honor. 7 weeks after that July 1st date has expired, and presumably if he wanted to cancel, he could have canceled and said, you're late. He doesn't say you're late. He says, can I close later in 2008?
Does that request negate the portion of the contract that says time is of the essence and the original date that's provided for the closing? I mean, because what this extension has really done is really extended 120 days past what it could have closed at. Correct?
Right.
So we're talking about 120 days that didn't go as far as the 120 days.
Right.
Does his request to have it extend even further than that constitute a waiver of the terms of the contract?
Yes, and that's exactly what we argue in our brief, that based on the time is of the essence clause, once you ask for an extension, time is of the essence goes out the window. You can't ask for an extension and then come back and after the time is done and say, wait, there was a time is of the essence, you had to finish earlier. Time is of the essence goes out the window once you request that extension, and that's what we argue in our brief. And Your Honors, if I may, if you don't have any more questions, I'd like to reserve 4 minutes for rebuttal.
Thank you.
Thank you, Your Honor.
Good morning, Your Honors. May it please the Court, Monica Serrato and David Reiner of Reiner & Reiner, PA, on behalf of the appellee, David Yu. I believe the issue of the breach has been thoroughly briefed out in our brief, so unless the Court has any specific questions on that issue, I would like to address the issue of waiver and ratification that was brought up in the reply brief.
The August 22 letter seems to be
the request for the extended closing date. Your Honor, the unrefuted testimony of Mr. Yu at trial established that the only reason he requested an extended closing date, not completion date, but closing date, was because he's a pilot. He thought he might be out of the country during that time, and so he sent an email saying, do you think you'd be able to accommodate a closing date until next year? Now,
as late as possible next year, not just next year, but as late as
allow
possible
for the fact that he may be out of the country. This turned out to be a moot point. Okay, because as he testified at trial...
But did the developer know that he changed his mind or it became moot? Or was that just a moot point after the fact? I mean, if you request something and you get it, and then you find out later you didn't really need it, is that negated?
There's a correction to that, Your Honor. We don't know if we got it. We have no evidence that they ever intended to agree to this. And in fact, to the contrary, 2 days after the TCO was issued in this case, they called him to close. So that doesn't look like they were willing to accommodate some closing date and wait later into next year. We never got a response from them. This is not...
Well, we don't know what would have happened. I mean, because none of that happened. He filed a lawsuit. He could have gone back and said, you know, what about my August letter to you asking to close later? Can I close later? I mean, we don't know what they would have said at that point if he would have followed through on it, because at that point he didn't want to close and he simply filed a lawsuit.
But the point is that they didn't respond to him one way or another. And if you look at the cases that they cite, first of all, the contract doesn't allow for oral modification. Yes, there's case law out there that says there can be an oral modification, but in those cases, both parties accepted and acted on the oral modification such it would operate a fraud on either party to refuse to enforce it.
What is the oral modification? What is
the later closing
oral
date.
Modification?
They're claiming that it's, by asking for a later closing date, somehow this operated as a modification.
This is not a question of whether there's a modification or not. It's a question of whether his act, a waiver is a unilateral act. His act alone in requesting an accommodation with respect to time waived his rights to insist on their complete agreement or compliance with the original statements of time.
We recall that the contract does have a clause in there that says the conduct of the parties can't operate to modify what the terms are. So, again, unless there's some kind of estoppel argument that they can raise.
Well, that's what it is. That's what it is.
What they raised is that way back in 2005, when they sent the modified date to him, he appeared to acquiesce to it because he said, I don't like it, but I can live with it. And then he waits until 2007 and asks for a further extension. Wouldn't that lull the developer into thinking doesn't have to meet the I guess it's November 1st deadline, that they can go past the November 1st deadline? It's only after the November 1st deadline comes and goes that he then tells the developer he's changed his mind and now he wanted to close earlier.
First of all, Your Honor, we dispute that his conversation, when he had received these amendments, his conversation with the developer constituted a waiver of the July 1st, 2000 date. Because a waiver is an intentional relinquishment of a known right. And in this case, he was misled by the developer to believe that this prospectus operated to amend the unit completion date until November, and so his testimony was clear. He opted to tolerate at that time because he thought he had no other choice. So under the case law, I don't believe that constitutes
when he consults a lawyer and determines what his legal rights are, then he knows that amending that date might have required more.
Right, but he didn't know that. The developer led him to believe otherwise. So frankly, we don't even believe that his option to tolerate at that time was an informed one such that it constitutes a legal waiver.
What about the August 22nd letter?
Again, because the contract doesn't allow for the conduct of the parties, there has to be some sort of estoppel, and they produced no evidence, no testimony, no witness, anything at trial to show that they in any way relied on this case as a detriment. If you look at the cases they cite that address this issue, there's always a reason for estoppel. In this case, we don't have that. We don't have, the developer saying, yes, we'll agree, or, all we have is, oh, we'll see, we'll pass it along to the title agent to see what we can do. This is not one of those cases where estoppel should absolutely apply.
Isn't the estoppel that in August, maybe if they had known, if he hadn't written this letter, they would have realized they had to close by a particular date, but based upon his representation that he wasn't concerned, the time was no longer of the essence to him. In fact, he wanted to extend the time, that they could take their time in getting their certificate of occupancy. Since they got it looks like they got it December 28th instead of November 1st.
That's speculation at this point.
Yeah, that's what we're saying.
They didn't produce any evidence, and, if they're going to raise this estoppel argument, they need to show that. They need to show reliance, and they didn't do that. So for them to raise it now, frankly, it's a bit too late. They should have raised it at trial. They should have had a witness say, hey, we relied on this, and that's why we didn't think we had to get the TCO in November. We waited until December. There was no evidence of that presented. So, respectfully, Your Honor, we do think that the lower court holding should
When was the CO issued?
December 28th.
December 28th?
Yes. Thank you, Your Honor.
Thank you.
Your Honor, briefly, in response, in order to get to the breach issue, first we have to find that we have a binding contract. We believe that the contract was binding, and the court's finding with respect to...
Well, just again, to go to the amendment question, what would be the harm in having the customary provision that if we're going to amend the material term of the contract, we have a signed writing? There's nothing signed by the buyer to accept the extended closing date, is there?
No, there is not, Your Honor, and that's just the practicality of the situation when you have developers developing 500-unit condominiums. That's why we have 718 in place, so we can send out...
No, I fully understand that as to amenities and various features that may change during construction. The hard time I'm having is with a term such as a closing date, where paragraph 28 tells us a date, and then we don't have a signed amendment to it. That's the question I have, is why don't we?
We don't have a signed amendment because the developer's belief, and most developers' belief, is that 718 allows them to make a change to the offering.
Well, it does it if the contract specifically says in paragraph 19C that the seller has the right to modify, change, revise, and amend without the purchaser's approval any or all of the documents other than the contract. Doesn't that exclude the conditions of the contract from the developer's ability to modify and change, and then give the purchaser that 15-day window to terminate if it doesn't agree with the modification?
Yes, based on the language of the contract. However, by sending that out and receiving nothing in response, and
we're back to that.
The old Book of the Month Club, negative notice.
It says you don't have it.
I'm sending you another book.
That's what 718 authorizes the developer to do.
If you say we cannot amend the terms of the contract, one of which is this. You say that you do amend it by sending out a letter saying we unilaterally want to amend it. That can't be.
No, it's not a modification of the contract. What we say is that they
It is a modification of the contract.
It cannot be because 19C prohibits it from being a specific modification of the contract.
So then what do you call it? A new contract?
No, you call it a waiver of that provision. The time is of the essence is waived once you...
But you got to have some obligation to waive it.
Yeah, our obligation is to build the condominium unit, which we did. He waived his right to get it by July 1st, 2007 by 2 years in advance, saying nothing, and in fact tolerating the fact that we say we're not going to be...
But the developer didn't waive its rights. The developer didn't waive its rights. The time is of the essence as to payment, closing date, et cetera, et cetera. It's a one-way waiver of time is of the essence.
Well, with respect to the buyer's conduct, it would be a waiver of the time is of the essence. There are obligations on the part of the developer.
Counsel, let us say arguendo, that you lose on that issue, that it's just a unilateral offer to extend, which is not accepted, and therefore not binding.
Yes, Your Honor.
So what else have you got?
Then you have a waiver to demand.
Waiver of what?
A waiver of the July 1st date by sending a letter to the developer saying, extend my closing date as late as possible in 2008.
But there was no evidence that that letter had anything to do with anything.
The evidence was that he sent that letter.
He sent the letter. There is no evidence that sending that letter had anything to do with any closing date, any completion date, anything, correct?
Of course it would. If you believe that you were supposed to close
Counsel, is there any evidence that you took any action, made any change in your plans, did anything upon receipt of, or as a result of the receipt of the letter?
That we changed our plan other than sending out a closing notice in response to receiving that letter. And
the closing notice came after he had already repudiated the contract, correct?
Correct, and after he asked for a later closing date at that point in time.
And it's kind of an interesting question because the closing date was only an estimate pursuant to the contract. It wasn't a...
Correct. It's an estimated substantial completion date. It's not a closing date. It's an estimated substantial completion date.
So there was really no closing date, really?
Well, it provides that you send notice of closing 10 days after TCO is issued. TCO is issued, it triggers the obligation on the part of the developer to send the notice.
So he wasn't asking for a extension of the substantial completion date. He was asking for an extension of the 10 days between the substantial completion and the closing, correct?
He's asking for an extension of the closing date.
Yes. But he didn't get that. He didn't get anything because you closed 2 days, you sent a notice of closing 2 days after that, after the substantial completion.
After TCO, we're obligated to send it within 10 days after the TCO.
You're obligated to do a lot of things under the law, and the fact that you do some things that you're obligated to do doesn't excuse you from doing the other ones.
Yes, but what option does the developer have when knowing 2 years in advance it's not going to be?
Poor baby.
Excuse me?
Poor baby.
No, at that point in time when they sell
the option is to follow the law.
When you know you're not going to be finished in time, you send out the amendment and you say I'm not going to be finished in time.
And if you're obliged by the terms of the contract to do something else, you have to do that. Otherwise, you're here.
Understood.
Thank you.
Thank you.